Over decades, Virginia's legal system has quietly drifted away from a constitutional republic framework into an unaccountable administrative hierarchy. This drift follows a predictable pattern. Courts have layered specific judicial doctrines upon procedural loopholes to consolidate power and insulate themselves from oversight. The first major consequence of this consolidation is the systematic denial of Seventh Amendment civil jury rights in state courts. By removing juries from the equation, single judges are empowered to act as unchecked, unilateral arbiters in property, financial, and administrative disputes. The second major consequence is the collapse of criminal justice transparency. Victims of crime are routinely sidelined by secret, in-chambers warrant dismissals negotiated out of public view. The legislature passes statutes claiming to prioritize public safety, but behind closed doors, judicial policies quietly favor deferrals and dismissals for violent repeat offenders. Without immediate legislative intervention, the state judiciary will solidify its status as a modern royal court, an institution insulated from the citizens it governs. The proposed legislative solution designed to break this judicial oligarchy is the Virginia Justice Restoration Act. Most strategists assume fixing a systemic problem requires a massive omnibus reform bill. In Virginia, that strategy guarantees immediate procedural failure. Article 4, Section 12 of the Constitution contains a strict single-object rule, mandating no law can embrace more than one object. To survive the legislature, the core theory of the Justice Restoration Act must be fractured into three separate, structurally distinct vehicles. We have to reverse engineer these three vehicles to understand exactly how they bypass both constitutional blockades and committee-level sabotage. In constitutional law, attempting to pass a unified theory of reform in a single package isn't a sign of strength. It is a fatal vulnerability. The legal root of the royal court problem traces back directly to the U.S. Supreme Court's 19th century interpretation of the 14th Amendment. This text is the original U.S. Bill of Rights. Article 7 establishes an absolute guarantee to a trial by jury in civil disputes, providing the baseline for citizen oversight in financial matters. But the 1875 precedent of Walker v. Savinet legally severed that guarantee at the state line. Through the doctrine of selective incorporation, the Supreme Court established that the Seventh Amendment does not apply to state courts, creating a two-tiered system of justice. Vehicle 2 of the reform package, the Civil Jury Restoration Act, is designed specifically to bypass this federal bottleneck. It directly targets and amends the Code of Virginia Title 8.01, rewriting the statutory framework for civil remedies. This statutory mandate explicitly strips state judges of the power to deny civil jury trials in financial disputes. It forces local compliance, rendering the federal loophole completely irrelevant. State statutory sovereignty can be weaponized to restore the precise civil rights that the federal Supreme Court abandoned. Shifting from civil disputes to the criminal justice collapse requires targeting the manipulation of the Code of Virginia Title 19.2. The primary mechanism of judicial evasion in criminal courts is the under-advisement loophole. Judges use this specific procedural mechanism to quietly defer sentencing and completely bypass statutory guidelines for violent repeat offenders. This is paired with a secondary abuse, in-chambers warrant dismissals. Active arrest warrants are routinely altered or dropped behind closed doors without generating a public record.
Vehicle 3 is the Warrant Transparency Act. It is the statutory weapon engineered to kill these practices. Vehicle 3 legally bans in-chambers warrant dismissals unless there is a formal public hearing, and it mandates strict, documented victim notification. Backroom judicial deference thrives in the dark. Mandatory procedural transparency is the only mechanical way to realign the courts with actual public safety. Superior constitutional theory means nothing if the bills are quietly assassinated in committee. The first institutional assassination method is the fiscal impact trap. Opponents argue that expanding civil juries under Vehicle 2 costs millions in juror pay. This automatically flags the bill for budgetary reasons, guaranteeing it dies in committee. The required countermeasure is a cost neutrality clause drafted directly into the Civil Jury Act. This clause mandates that corporate plaintiffs pay a nominal jury demand fee. It neutralizes the state budget argument entirely by ensuring a $0 fiscal impact. The second and far more insidious institutional trap is the passed by indefinitely, or PBI motion. A PBI motion is a coward's veto. Committee chairs use it to indefinitely study a bill, allowing them to kill the legislation without forcing their members into a recorded public vote. The bill's sponsors must execute a strict floor strategy to survive this trap. They must preemptively interrupt the chair with a motion for a yeas and nays recorded vupt, the exact moment a table motion is hinted at. Legislative drafting is combat. Every bill must be structurally pre-engineered to legally corner opponents and force them onto the permanent public record. Stepping back from statutory combat, we have to address the foundational root of the crisis. Who actually hires the judges? The historical warnings of the Anti-Federalists in Brutus No. 15 and Thomas Jefferson's letters from 1820 predicted this exact structural failure. They warned that giving judges lifetime or unchecked appointments would strip power from the citizenry, creating an independent legal oligarchy more powerful than a king. This Chart of Rights, drafted by George Mason in 1776, explicitly dictates that the legislative and executive powers should be separate and distinct from the judicative. Virginia's current system, where politicians unilaterally handpick judges, violates this original text. This necessitates Vehicle 1, the Citizen Grand Jury Amendment, a joint resolution to amend Article 6 of the Virginia Constitution. Its function is absolute. It completely removes politicians from the judicial appointment process, transferring the power to vet, hire, and fire judges to a randomized citizen judicial grand jury. Statutory band-aids are temporary.
True accountability is only achieved when the ultimate authority over the court is returned directly to the citizenry. The complete strategy relies on 3 separate, highly specific vehicles designed to bypass a single constitutional firewall. Executing this multi-front legislative war requires massive institutional weight and highly coordinated coalition partners. It requires primary sponsors like Delegates Davis and Williams to drive the statutory bills, and senior institutional muscle like Delegates Kilgore and Leftwich to signal unity and force the package through the committee gauntlet. Successful judicial reform demands the precise alignment of historical jurisprudence, constitutional mechanics, and ruthless committee tactics. The Virginia Justice Restoration Act demonstrates how to systematically dismantle an entrenched administrative state using uncompromising procedural discipline.